Okay, let's unpack this.
Hmm.
We've all been taught that confidentiality is, well, it's the sacred foundation of medical practice.
Right.
It's a promise.
It's the promise you make the moment you meet a patient. Absolutely.
But what happens in those moments when keeping that promise might result in a child being harmed or, I don't know, an innocent member of the public being killed on the road?
That is the central, unavoidable ethical tension in modern medicine. I mean, consider a patient you've just diagnosed with a serious recurrent seizure disorder.
Okay.
They know they shouldn't drive, yet they look you in the eye and insist, I'm going to keep driving,
Yeah.
and you keep this a secret.
Right. Or maybe the patient is a competent adult. They trust you enough to disclose domestic abuse, but then they beg you, please don't tell anyone.
While you know a 5-year-old child lives in that same home.
Exactly. And the dilemma is just, it's instantaneous. It's agonizing.
And these aren't abstract philosophical problems. They're the precise, high-stakes, high-frequency scenarios that, every doctor in the UK is going to face at some point.
So today, we are doing a deep dive into the GMC-aligned rules, the ethical and legal framework that dictates when confidentiality must or may be broken without consent. We're going to give you the shortcut to mastering this balance. We're not trying to replace the guidance, of course, but to structure your approach so that when that decision hits, you have a solid, defensible process ready to go.
That's it, exactly. And while we'll save the full framework for the end, the general principle is really this. The duty to protect the public from serious harm, or the duty to obey the law, it overrides the duty of confidence.
And this is a big but.
A very big but. Critically, you must always take the minimum necessary step to mitigate that risk. Never more.
Okay, so let's start by establishing the landscape here. Confidentiality is the default, but our sources clearly define limited situations where information must or may be shared. Can you sort of break down the 3 core pillars for us?
Certainly. Think of these as the 3 main buckets of justification.
Yeah.
They give you the legal and ethical anchors you need.
Okay, so pillar 1, the one that often feels the most immediate.
That is safeguarding. This covers the legal and moral requirement to protect a child or a vulnerable adult who is at serious risk of harm, abuse, or neglect.
So if you suspect an adult or a child is at risk, this duty kicks in.
It does.
Pillar 2. This one seems to require the heaviest ethical judgment.
That would be public interest. This is when a disclosure is necessary to prevent a serious crime or serious harm to the wider public.
The unfit driver is the classic example,
A
right?
classic example. Or perhaps a credible threat of severe violence against an identified third party.
And the third one, the clearest and I suppose least subjective pillar.
That's statutory or legal duties. This isn't a choice. It's a legal requirement. A statute, an act of parliament, or a court order. They require you to share specific information. You simply must comply.
That really highlights the difference between must and may, doesn't it? When we look at the GMC principles, how do we distinguish between mandatory compliance and that balancing act?
Well, the must is defined by the law. Statutory duties. If the law explicitly says you have to disclose, you have no choice. You do it.
But you still have to be careful.
Oh, absolutely.
Yeah.
You still ensure you share only the relevant details.
And what about the may side? The public interest disclosure. That seems far harder because you have to weigh the odds.
It is much harder. The GMC guidance allows you to disclose information without consent to protect others, and that's the core of the public interest bracket. When you're deciding, you have to look at 3 factors.
Okay, what are they?
The likelihood of the harm happening, the severity of that harm. Is it trivial or is it life-changing? And critically, the imminence of the risk.
So if the harm is highly likely, severe, and about to happen,
Then the public interest in disclosure generally overrides patient confidentiality.
and across all 3 of these pillars, there's one non-negotiable principle, which is transparency and proportionality.
Absolutely vital.
Uh,
And it's often what trips people up. The principle is you must always apply the minimum necessary rule.
Only share what's absolutely needed.
Precisely. Just the details required for that specific purpose. You have to use verified, secure channels, no personal phone calls, no unencrypted emails, and you should always aim to inform the patient about the disclosure. Unless doing so would actually increase the risk to them or someone else, or, prejudice the prevention of a crime.
Okay, let's focus on the easiest category first. Statutory duties. Here's where it gets really interesting, because these are the clearest must-dos. They're non-negotiable.
Yes, and the highest yield example here is notifiable diseases, or NOIDs. If you're a registered medical practitioner, You must notify suspected notifiable infections to the UK Health Security Agency, UKHSA.
It's a public health requirement.
It is. You do it via the specified electronic system.
And as our sources noted, this isn't a static field. The list was actually expanded from April 2025, which really underscores the need to stay current.
Precisely. Let's use the measles scenario. A child is diagnosed, parents are embarrassed, maybe fearful of isolation, and they ask you to keep it quiet.
You can't.
You cannot collude. The correct action is to notify UKHSA immediately because it is a legal mandate. You then explain this legal duty to the parents.
And the wording is important there, I imagine.
Very. Something like, I am required by law to share only the necessary facts with UKHSA to protect the wider community.
That clarity helps a lot. What about injuries involving violence?
Gunshot and knife wounds? Another mandatory notification? You are required to inform the police promptly.
But this is a beautiful example of that balancing act you mentioned.
It is. While you must inform the police of the injury, you still maintain your duty of confidentiality about the patient's full history. You only share the minimum details about the wound itself.
So you're not handing over their entire medical record for the past 20 years?
God, no. You manage the identity disclosure according to GMC guidance. It's very specific.
So even when the law forces your hand, that principle of proportionality still governs how much you release.
Exactly. The duty to comply is absolute, but the information shared must be proportionate to the legal need.
Okay, now we shift gears. Let's move to the areas that truly require ethical and clinical judgment. Public interest and safeguarding. Let's tackle safeguarding first.
This is a huge area, and a critical clarification is needed right away.
What's that?
In most safeguarding scenarios, consent is not required to share information. If a child or vulnerable adult is at risk, that concern is paramount.
Okay, wait. Let's really get into this. If the patient is a competent adult and they're disclosing abuse they suffered and they beg you to keep it secret, even if a child lives there, doesn't overriding their request completely erode trust? I mean, it might stop other patients coming forward. How do you justify that?
That is the absolute core of the dilemma, and you've hit on why these cases are so challenging. The justification lies in a sort of hierarchy of duties.
Go on.
While confidentiality builds trust, the duty to prevent serious harm to a third party, particularly a child who cannot protect themselves, is generally considered the higher duty. The GMC supports the decision to share the minimum necessary information to mitigate that risk to the child, even without consent.
So who do we talk to? Where does this information go?
You share the minimum necessary information with the right authority. Usually that's the internal hospital safeguarding team or the multi-agency safeguarding hub.
MSH.
It's the central local authority body. It brings together police, social services, and health to coordinate responses. Knowing that acronym, that route, is essential.
Okay. Let's move to the other big judgment call. Fitness to drive. The DVLA, or DVA. This is the classic public interest dilemma.
It is the ultimate balancing act, yes. And disclosure without consent is only justified if two things are true.
What are they?
One, the patient continues to drive while medically unfit. And two, they explicitly refuse to notify the DVLA themselves. A doctor cannot be complicit in a risk that threatens public safety.
Let's use our initial seizure patient to walk through the proper 5-step process here. So our patient is competent, they have recurrent seizures, and they're refusing to contact the DVLA.
Okay. Step 1. Assess risk and purpose.
Yeah.
Is the patient actually unfit to drive?
In this case, yes. Recurrent seizures. That's a significant, severe risk to the public.
Right. So the purpose is mitigating that immediate public safety risk.
Step 2.
Counsel and choose the route. You must first counsel the patient, making it crystal clear that it is their duty to inform the DVLA. If they refuse, you identify the correct authority, the DVLA.
Then step 3, be transparent and warn.
Yes. Before you act, you must warn the patient explicitly. I intend to disclose this without your consent to protect the public. You have to give them a final chance to comply themselves.
And often that's enough, I'd imagine.
It can be. But if they still refuse, we move to the action stage. Step 4. Share the minimum necessary.
Exactly. You're not sending their entire 300-page hospital file.
No. You make a proportionate disclosure, a factual summary. Confirm the diagnosis, the recurrent nature of the seizures, and the patient's refusal to inform the DVLA, and you use secure channels.
And then step 5, which is maybe the most important for your own defensibility, document.
Document everything. The legal basis, public interest, the specific facts of the risk, the date, time of your counseling and warning, exactly what was shared, with whom, when, and how, and why the patient's refusal made your action necessary.
That detailed process makes what is a very difficult decision defensible. So, what does this all mean when you are under pressure? You need to spot the traps.
The traps almost always involve failing to act on mandatory duties or failing to apply that minimum necessary rule.
What's a common one?
A frequent trap is refusing to share information for safeguarding because the doctor is, mistakenly afraid of GDPR says no.
That is such a common fear.
It is, but GDPR allows sharing for safety under a lawful basis other than consent. The duty to safeguard trumps a misplaced fear of data protection laws.
Another classic trap is oversharing.
Yes, never ever disclose full notes when a brief factual summary is all that's needed. Oversharing breaches proportionality.
And using the wrong method.
Using personal email or WhatsApp for identifiable patient data. It's unprofessional, it's insecure, and just failing to act. If a disease must be notified, do it. If our unfit patient insists on driving, you must act on the DVLA disclosure.
To help cement this process and the core principles, let's look at 2 high-yield memory aids from the source material. We can use the DVLA scenario as a backdrop.
Okay, let's use Lawful SHARE. It focuses on the reasoning. So
Okay.
L is for identifying the legal duty or public interest. In our case, it's public interest.
A is for identifying the correct authority, so the DVLA.
WA is for recording why. You document the rationale. Patient refused to report poses a risk.
F is for few facts, the minimum necessary.
U is for use secure channels. And L is for let patient know if it's safe. In the DVLA case, you must let them know beforehand.
That framework maps really clearly onto those judgment calls. Now, what about the other mnemonic, safe law?
This one is more about the procedural elements. So S is for safeguard risk, which includes public safety. A is for act on statutes. F is for focus on minimum.
E for explain if safe. L for log decisions.
A is for approved channels. And W is for ho when recorded. They both just reinforce the same defensive process, really.
Finally, let's talk about practical language, because when you have to make that disclosure, transparency is probably your strongest tool.
It is. Use phrases that focus on the requirement, the legal or ethical duty. It removes the personal choice aspect of it.
So for the DVLA situation,
You use firm, professional language. If you continue to drive while medically unsafe, I am obliged to inform the DVLA in the public interest. I will make sure I only share what is absolutely necessary. It grounds the action in public duty.
this has been an incredibly clear breakdown of what is usually a very complex ethical tightrope. Let's summarize the absolute core takeaways.
Okay. First, confidentiality is broken only when it's explicitly required by law, your statutory duties, or when it's necessary to prevent serious harm. That's public interest or safeguarding.
Second, always apply the minimum necessary rule and disclose only to the right authority, whether that's UKHSA, the DVLA, MASH, or the police.
And third, thorough documentation. Your rationale, the steps you took, why you chose to inform the patient, or why you didn't, it's absolutely essential for your defensibility.
Let's just briefly define a few of those key terms. So, statutory duties.
Those are legal duties imposed by Parliament. You must follow them, like reporting certain diseases.
Public interest disclosure.
That's the act of sharing information to protect the wider public from serious harm when a patient refuses to act themselves.
And MASH.
The multi-agency safeguarding hub. It's the critical coordinating hub for sharing those safeguarding concerns across agencies.
And finally, minimum necessary.
It's the governing principle. You only share the precise facts strictly needed for the purpose of the disclosure and absolutely nothing more.
The source material reminds us of that image, the balance scales overlaid by a shield. Privacy versus safety. It's that constant documented balancing act that makes medical practice more than just belying science.
Absolutely. When protecting the public means overriding a personal promise, the pen, that is, the documentation of due process and sound rationale, truly becomes mightier than the secret.
Keep learning, stay sharp, and always act in the patient's and public's best interest.